This is Barry Zalma on insurance. Today, we're going to speak about how an adjuster working with the insured or the insured's public adjuster can establish the amount of loss and claim of a structure loss to aid the insured in his or her obligation to prove the loss. The adjuster must, on the first visit, establish with the insured a detailed scope of loss. This means that the adjuster and the insured, or the insured with his or her public insurance adjuster, must walk through the insured's house or business structure and agree to exactly what was damaged and or destroyed as a result of the peril insured against, usually something like a fire. The adjuster can get this agreement orally with a tape recorder or write it down on paper. The scope of loss must be detailed. Descriptions including room dimensions, materials like moldings, flooring, wall coverings, and fixtures, information about special features, openings like windows and doors, casements, detailing, moldings, and other architectural features must be part of the scope of loss. The scope of loss must be as complete and accurate as possible on a first inspection. The adjuster must never, at the time of the first inspection of the damaged property, take a quick look around and ask the insured to fill out a property loss form at his convenience. Leave the insured with blank forms except for supplemental items learned of after the initial scope was completed. Take a partial scope and attempt to do the rest later. Rely on the expertise of the insured's public adjuster, or rely on a construction contractor to establish the scope. The adjuster must never make promises that cannot be kept, nor commit to payment before the amount of loss and claim is agreed, nor should he ever or she ever commit to coverage when there is an issue raised by the facts and policy conditions or exclusions. The adjuster must advise the insured that the adjuster will, if necessary, be retaining experts in the valuation and repair of the type of property that is involved. These experts will bid on the repair and replacement from the agreed scope, so that when bids are compared, the comparison will be easy, comparing apples to apples and doors to doors and windows to windows. The adjuster should explain to the insured that the scope of loss may change when some demolition is done or when an expert examines the property that would require a change to the extent of the scope, and that it is just a first evaluation based only on visible damages. Before any estimates for repair are prepared, the adjuster must present the insured with a copy of the agreed scope and inform the insured that he may, if he wishes, obtain similar opinions based on the same agreed scope from contractors or experts of his own choosing. The adjuster should provide at least 2 general contractors, different from the construction consultant used by the insurer if one was used to help the adjuster set the scope, with a copy of the adjuster's scope of loss. Each contractor should prepare detailed estimates of the cost of repair based upon and written in the same order as the adjuster's scope of loss, so that the adjuster can identify the low bidder. The adjuster then should prepare an estimate of the cost of repairs for comparison with the estimates made by the contractors using the scope of loss and estimating programs like Xactimate, Marshall & Swift, or Beck's. Once the adjuster and the insured have agreed to the scope of loss, the adjuster should have the insured sign the form agreeing to the scope. If the adjuster used a tape-recorded version of a scope, digitally or video recorded, the scope of loss, then the insured should be asked to sign the tape itself or a transcribed copy of it. If the adjuster does not have an agreed scope of loss at the beginning of an adjustment, the loss will invariably be larger when it is finally put together by the insured's contractor, or the insured's public adjuster working with the insured's contractor. The adjuster, or the adjuster working with a construction consultant, should evaluate any increased scope of loss to reach agreement with the insured's contractor, or the public adjuster. It is what an adjuster does. It is a negotiation to reach an agreed amount of loss. Similarly, when dealing with the loss to personal property, just like the structure scope of loss, the adjuster and the insured should agree on the content scope of loss by creating a list of each item of personal property claimed damaged or destroyed in the loss or stolen. This scope of loss can easily be completed on audio tape or digitally on a smartphone by walking through the structure with the insured or the insured's public adjuster, identifying each and every item or groups of items damaged and destroyed at the scene of loss. The insured should then be provided with forms for providing information about the personal property claimed damaged, destroyed, or stolen. The schedule provided should have available columns that allow the insured to provide detail from the scope of loss as to each item, with 1. A detailed description, 2. Its date of purchase, 3. Its place of purchase, 4. Its purchase price, 5. Its actual cash value or fair market value at the time of the loss, 6. If repairable, the cost of repair, 7. Attach supporting purchase receipts or invoices or sufficient information about the place of purchase to allow the adjuster to verify the claim, 8. Attached estimates prepared by personal property repairers or salvers, and 9. A list of items not noticed on the original scope of loss. The adjuster, working with the schedule and with the assistance of a professional salvor or other personal property expert, is obligated to establish the value, if any, of the totally destroyed items. If the loss is extensive, the adjuster may find it necessary to hire a salvor or other experts in personal property scheduling and valuing to perform a complete inventory for the insurer. If the adjuster does not have an agreed scope of loss at the beginning of the adjustment, the loss will invariably be larger when it is finally put together by the insured or the insured's public adjuster. Failure to obtain an agreed scope of loss is evidence that the adjuster has failed to fulfill his or her obligation to complete a thorough investigation of a loss and a violation of a major obligation imposed by the insurer on all of its adjusters to thoroughly investigate each claim fairly and in good faith. If the insured and the adjuster cannot reach an agreement as to the amount of loss and claim, It is appropriate for the adjuster to demand that the insured present within 60 days of the demand a sworn statement and proof of loss. The California Insurance Code, Section 2057, provides, with regard to the proof of loss, quote, under a contract of fire insurance, payment to the insured shall be made within 30 days after the amount of loss and the liability of the company has been agreed upon or settled by the insured and the company in writing. If the company fails to pay within 30 days, the payment shall bear interest beginning the 31st day at the prevailing legal rate. The company also shall be liable for all costs collection, including reasonable attorney's fees if legal action is necessary to obtain payment after the company has willfully failed to pay within 30 days. Of course, if there is no agreement, it is the obligation of the adjuster to respond to the insured's proof of loss by either accepting it and making payment, or rejecting it and explaining why. Many adjusters misinterpreted the code section to require a response to a proof of loss within 30 days of its receipt by the company. The section does not impose such a requirement. The section merely changes the standard fire policy's promise to pay after there is an agreement between the insured and insurer within 60 days of the agreement and reduces the amount of time to 30 days. The statute sets out methods for enforcing failure to pay promptly, and it codifies a simple fact of business life. It is insurance business suicide to delay payment of a claim once an agreement on the amount has been reached. If the adjuster representing the insurer and the insured are not in agreement on the compensability or the extent of loss, submitting a blank proof of loss to the insured and requiring its completion sets in motion a method to resolve a claim where there is no agreement. Responding to a proof of loss does not require acceptance. The adjuster may reject the proof of loss as incomplete, excessive, or not in compliance with the policy conditions. If incomplete or excessive, the adjuster should give the insured a limited time to present a complete proof of loss. The adjuster should be careful not to waive the 60-day proof of loss requirement inadvertently. It should be waived only in appropriate cases for a specified period of time, but should never be an open extension. If the adjuster has waived the 60-day time limit expressly or by action, the adjuster must demand the proof of loss be presented to him or her on a certain date. I recommend not less than 30 nor more than 60 days after the demand. The extended time should not be extended further than 60 days without an exceptional good cause. When the proof of loss is received, the adjuster must recognize that most policies have no language defining what a reasonable time is to respond to a proof of loss. Depending on the facts, a reasonable time can be as short as 15 calendar days and as long as 1 year. My recommendation is that the adjuster attempt to respond in some way to any proof of loss as soon as possible, but no later than 30 to 40 days after its receipt. If the insurer is not able to respond, it is best to explain in writing to the insured the inability and what is needed for the proof of loss to be complete and for the insurer to accept a proof of loss. The Fair Claim Settlement Practices regulations, enacted in many states, following a National Association of Insurance Commissioners model set of regulations requires response to the proof of loss or proof of claim immediately, but no later than 40 calendar days after receipt of the proof of loss. That is more than sufficient time to respond. If there is a problem meeting the time limit, a written agreement to an extension should be obtained. The adjuster may, as appropriate, require a delay by stating 1. That the investigation is incomplete, 2. That the experts have been retained who require at least 90 days to complete their work, 3. That counsel has been retained to advise the company and it is expected to take 30 to 60 days to complete counsel's research, or 4. Any other honest and reasonable excuse available, and those excuses must be presented promptly to the insured and in writing. If the adjuster does not have an honest or reasonable excuse, the insurer should either accept or reject the proof of loss without delay. There is no reasonable excuse for lying to an insured. A false excuse can be evidence of bad faith claims handling and has, when used, resulted in multi-million-dollar bad faith judgments. If the adjuster and the insured cannot agree on the amount of loss and the benefits available to the policy, the adjuster should consider working with the insured, if the only dispute is as to the quantum of the loss, to enter into an appraisal so that the insured and the insurers, arbitrators or appraisers can meet and come up with an amount of loss and an amount of claim promptly and fairly without any prejudice, so that that amount of loss and claim can become a judgment of a court. This video was adapted from my book, The Compact Book on Adjusting Claims, 3rd edition, which is available as both a paperback and a Kindle book from Amazon.com. If you found this video to be interesting or useful, please pass it on to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications, so that you can be advised of future videos and future blog postings. Please also click on the like button on YouTube or the Rumble button on rumble.com to show your appreciation. Thank you for your attention.